G'day everyone, welcome to video 3.2.5 for the Legal Studies guy. Really keen to get this through in under 20 minutes today after the last two have gone a little bit over, so we'll jump straight through to it. Quick quote today, wonder just enough, then go do, very much in line with some of my recent messages about, just keep turning up. You're not always going to be motivated, but all you can do, you're not always going to feel great, but all you can do is just keep turning up. It's the same here. Don't sit around wondering what could be. Don't sit around waiting for some inspiration to come. Just get out there and do. And hopefully that includes study, which you're all doing right now. So we'll whip through this one pretty darn quickly. We are today looking at civil pre-trial procedures and particularly the purposes of them. What that entails, or what these slides will include, is straight up, hey, these are the purposes of civil pre-trial procedures, just that direct information. But then we are going to look at three pre-trial procedures that occur before a civil trial in the Supreme Court, because the key skill clearly asks us to explain the purposes of pre-trial procedures using examples, meaning using some specific pre-trial procedures to illustrate how those purposes are met. At the end of this, obviously, you are going to be able to tell us what the purposes of different civil pre-trial procedures are. We are going to look at three pre-trial procedures to work through this. The first is pleadings, which is the official start of a civil dispute. Obviously, the official start of a civil case. A dispute occurs or starts when the harm occurs, but this is officially when the matter reaches the courts. We then look at the exchange of evidence, which is discovery, and then finally directions hearings, which we've talked about a little bit before when we talked about conciliation, because it is conciliation that is used in directions hearings, where the judge kind of takes control and offers suggestions to the parties. We will look at these three in more detail, and we will look at how these three achieve these general purposes of civil pre-trial procedures. And importantly, the key word here is civil pre-trial procedures are about information. It is about the exchange of information. It is about both parties talking to each other and talking to the courts before you end up in a formal trial. Okay? Because what's going to happen is if you get to a trial and the parties haven't engaged with each other previously, they haven't talked about what they're trying to argue, they haven't talked about what evidence they have, you're going to end up with a trial that's going to have major delays as parties scramble to catch up and scramble to develop new arguments, etc. So what the whole purpose of this is to make sure that both parties are on the same footing, both parties have the same information, so a bit of equality there, to make sure a trial can be run quickly, so a bit of access, and smoothly, and ensure a fair and just outcome. So lots of principles of justice involved here. So civil pre-trial procedures inform each party, okay, because each party will first and foremost know a dispute exists. So you're not going to have something end up in court and get resolved about you without you knowing about it. These pre-trial procedures then inform you of what the claims are. So they tell you that there is a dispute, then they tell you what the claims being made are, and eventually what evidence is being used, what evidence is being used to support those claims. Not doing very well here with the computer. And what evidence is being used to support those claims. So, first and foremost, there is a dispute, then what's being claimed, and then what evidence is being used to support those claims. So parties are going to know exactly what's happening. Okay, they're going to be informed. It also helps inform the court, because again, it would be no good if you intended to take someone to court, but then the court didn't know about it and couldn't schedule your trial in. So what this process means or helps ensure is that the court has all the information at hand. The court knows how many witnesses there's going to be, knows how many documents are going to be presented in court regarding the evidence. They know how many claims are being made and how many things are being disputed. This allows them to then schedule that trial in. Okay, how many days are we going to need to hear this? How much time is this going to take, etc., etc. So it allows the court to schedule proceedings appropriately. Beyond that, it also provides the judge with information to use in directions hearings, so that he can make, or she, not being gender specific there, can make suggestions to both parties about how the dispute could potentially be resolved without actually going to trial in the first place. So it helps inform the court. And ultimately, what might happen in those directions hearings as well is it starts promoting discussion, because you're sharing these documents and you're sharing this evidence. So it starts promoting actual dialogue between the parties, which potentially leads to a settlement, potentially leads to the parties negotiating a little bit. And you never know, you might actually resolve the dispute without ending up a trial at all. Now, obviously, as we know, this would be fantastic for ensuring that the backlog of cases that the courts have is reduced, so that more people can have their dispute resolved, therefore improving access. Okay, and this might be the fact that some parties concede on some issues, and it means you have a shorter trial. But it may mean that a party can really see how weak their case is, and they might see that we are inevitably going to lose this. And as a result, they'll enter into negotiation and try and have some control over their settlement. Again, information, informing the parties, and getting them to a point where they can have conversation and discourse about the dispute is the overall purposes of these pretrial procedures. Without further ado, let's look at 3 of them specifically. Starting with pleadings. Okay, pleadings is, as I said, the exchange of legal documents, okay? Not evidence, which is going to be discovery, the exchange of legal documents. And there's 5 specific documents that we're going to go through and look at that are exchanged. So pleadings is when a civil dispute, so let's say a dispute starts when the harm occurs, but when a civil dispute actually becomes a case, so it actually becomes something that the court is aware of and the court knows that they might need to resolve, that starts with pleadings, and particularly that starts with what's called a writ. Okay, the writ is the legal document. It is a document. I'll provide you a link later on, and I'll show you an example of a writ actually. It is a legal document that sets out that I, Daniel Garner, am going to sue Joe Thomas. Okay? It really clearly says, I'm going to sue you, and this is the reason why. A copy is filed with the courts, and a copy is given to or sent to the other person so that they know a dispute has started. Now, I'm not saying that there needs to be nothing or no communication to the parties prior to this. We know that parties might have negotiated, because you've got to look at negotiation options before you initiate a civil case. Okay? So there might have been negotiation options used. There might have been what's called a letter of demand. For example, if you're going to sue someone for defamation, before you file a writ with the court and actually officially commence proceedings in the courts, you might get your lawyer to send them a letter that says, hey, we are going to start civil proceedings unless you take these actions. And you might refuse to, or they might refuse to, so you might file the writ anyway. So we're not saying that when a writ's filed, it's the absolute first thing that happens after harm has occurred. Usually there has been some negotiation first. Usually there has been some involvement of lawyers with letters of demand, etc. But if you've had no success, what you do is you file a writ. You go to the courts and you hand in the paperwork and you say, I want to start a civil case against this person. And usually attached to that writ is a statement of claim. Okay, this is again prepared by the plaintiff, and this includes basically detail of what the claims being made are. I'm claiming that you breached your duty of care because you did this, and you did this, and you did this, and that is a breach. So it really clearly sets out what claim is being made. Okay, so both of these documents are prepared by the plaintiff, and they usually go attached together, and they go to the court and they go to the defendant. Okay. The next stage of pleadings, or the next 2 stages, are the responsibility of the defendant, and they are the notice of appearance and the statement of defense. So these are the responsibility of the defendant. Notice of appearance is really, really straightforward. It's just essentially a notice that's sent to the courts and back to the plaintiff that says, yes, I'm aware, I got your writ, I got your statement of claim, I'm going to defend those claims made, I just want to let you know that I got it. So it's just kind of like that, before you have an appointment, they send you a message and that says, please remember you have this appointment at 10 a.m. tomorrow. Please reply yes if you intend to attend. It's the same with the courts. They send you the written statement of claim and they ask you to file a notice of appearance saying that, yes, I received your writ. I intend to defend myself, and then I will send a statement of defense at a later date. And then the defendant will prepare a statement of defense. So the statement of defense is the opposite of the statement of claim. It is addressing the claims made. So you made this claim, I'm going to defend myself because I say this, so on and so forth. So it's a direct response to that statement and claim. It could potentially include allegations that you admit to, but generally it will be you saying how you are going to defend yourself against the claims made. There are timelines placed on these, depending on where you live for the notice of appearance. So if you live in Victoria, or if you live interstate, or if you live in Papua New Guinea, or if you live internationally, there are different time frames. Generally, I think if you live in Victoria, and I can double check this, you need to return your notice of appearance within 28 days. Or 4 weeks, and then it extends out from there. The final stage of pleadings is a counterclaim, and this is optional, and this is why it's kind of, we can sort of cut it off a little bit there. The counterclaim can be filed by the defendant if they also intend to sue the plaintiff. For example, say that you are a builder and you have a contract with someone, and that contract says you will build a 4-bedroom house. You only build a 3-bedroom house. They might sue you and say you need to come and fulfill this contract and build the 4th bedroom. You might respond and say, well, actually, I didn't build the 4th bedroom because you didn't meet your payments. I'm going to sue you for the amount of money you owe me. That would be an example of a counterclaim where it is effectively the same dispute, but both parties are attempting to sue each other. And this would be heard as one proceeding, okay? You wouldn't come back for a second proceeding. It would be dealt with in one go, okay? So that way, again, trying to save the court's time and trying to save the court's money. Here is an example of a writ. This is for that Falls Festival class action that I've talked about before. You'll see here in this example, it says Michaela Joy Burke, the plaintiff, and Ash Sounds Proprietary Limited, trading as the Falls Music and Arts Festival defendant. Writ. So on and so forth. This action has been brought against you by the plaintiff for the claim set out in this writ. If you intend to defend the proceeding, you must give notice. Notice of appearance must be filed, and here's our timelines. If you are served with the writ in Victoria within 10 days, not 4 weeks as I said, I apologise, 21 days if you live outside of Victoria but in Australia, 28 days if you live in Papua New Guinea, within 30 days if you live in New Zealand, or if you live outside of the country and not in New Zealand or Papua New Guinea, you have 42 days to file a notice of appearance. But back to that one, if you are in Victoria, you only have 10 days to basically respond and say, yes, I'll defend myself. So you've got to act pretty quick. That's what a writ looks like, really, really formal legal document. This is what a statement of claim looks like. And a statement of claim is, as you can see, a little bit more detailed. So statement of claim, again, same dispute, same plaintiff, same defendant. And we go into a lot more detail. At approximately 9:50 p.m. On 30th of December, a large number of young people were injured at the Falls Festival at Lawn, so on and so forth. And then you'll see here we get to particulars of breach of duty. We are claiming that you failed to ensure the theatre had an adequate safe exit. We are claiming that you restricted the area of exit in a manner which caused crushing, so on and so on. We are claiming that you failed to have adequate marshalling. We are claiming that you failed to provide adequate instruction to patrons about movement, etc., etc. This is, as I said, a lot of detail about what exactly you are claiming, what exactly you are saying caused the harm. When Falls Festival files their statement of defence, they might admit, yeah, we admit that we didn't give adequate instruction to patrons, so we're going to admit that claim. As I said, you may admit to some allegations. However, we believe we had adequate marshalling, and this is, what we're going to say there. Well, we believe there was adequate surfacing, we use this, so on and so forth. So it would be responding to these claims that are being made here. So as you can see, these are both contributing to that idea of informing the parties and potentially promoting a settlement. Because you have more of an idea about what the other party's saying. You have an exact idea about what claims they're going to make, and then you know exactly what to do in terms of finding evidence to either support or defend yourself. Next up, we have discovery, and I'm at 16 or nearly at 17 minutes, so we'll fly through these ones. This is from the Civil Procedure Act of 2010. Okay? So this is the document passed by the Victorian Parliament, which outlines how a civil procedure should be followed. And disclosing existence of documents. A person to whom the overarching obligations apply, aka a plaintiff or a defendant, must disclose to each party the existence of all documents that are or have been in that person's possession, of which the person is aware, and which the person considers or ought reasonably consider are critical to the resolution of the dispute. AKA, if you have a document that does not support your claims, okay, and maybe supports the defence, you still need to disclose it to the other party. So this is what discovery is. Discovery is the full and honest disclosure of all the evidence you have that is critical to the resolution of the dispute, regardless of whether it supports your claim or not. When you hear on TV shows people talk about burying the evidence, trying to hide evidence that doesn't support them, that isn't only unethical, it is actually against the law in Victoria. Okay, the Civil Procedure Act says that you must disclose the evidence even if it doesn't support your case. Any evidence that you intend to use in trial, you must log on an affidavit of documents, so you must keep a list of it. At any point, either party can request to see a copy of the other party's affidavit, and they can request any documents that are off that affidavit of documents, aka any evidence you intend to use, I can see before the trial. You can see how this helps keep the parties informed. It helps promote resolution of a dispute because you might see the evidence against you and decide to try and find a settlement. And it ensures that you can resolve a dispute in a speedier manner at trial because you're not having adjournments and delays for new evidence that's arising. The only way you don't need to disclose a document is if it's the subject of privilege, such as conversations between you and your lawyer, etc., that you don't need to hand over. Another uncommon aspect of discovery is interrogatories, where you might send a list of written questions to the other party that must be completed in a time frame and under oath, but this is quite uncommon and quite rare. But again, that would obviously help inform each party of the nature of the claims being made. Finally, there are directions hearings. This is a super quick one. We've talked about this with conciliation. A directions hearing is a conference between a judge or potentially an associate judge and the two parties. And the judge or the associate judge may make any order that they think will assist in the prompt, effective, and economical resolution of the dispute. We are going to cover this in more detail in case management powers or powers of judicial case management, which is 3.2.8. So we won't go into a lot of detail here because I have just ticked over 20 minutes. But this is things like they may order compulsory mediation, send you to arbitration. It may just be about timetabling witnesses, or you might start discussing and agreeing on relevant questions of law. So, what does this actually look like? So super quickly, just so that we don't think that all of a sudden, just so we don't think that they all go back to back. So you have pleadings finishes, then you start discovery, then discovery finishes, then you have directions hearings. Let's say that this is the harm occurring, and this is the resolution of the dispute. Obviously, there's a lot of stuff that can happen in there. It looks like it says warm. We'll change it to say harm. Okay. Obviously, the trial itself, when you end up in the courtroom, okay, might only be a little part of the end of it when you finally get to your resolution. Okay? And we'll talk about remedies and stuff before the end of this unit. And we might not actually end up at court or filing our dispute with the court until we go through a range of things like negotiation options. You might maybe, you wouldn't go through VCAT because they provide a binding resolution, but you may have engaged with Consumer Affairs Victoria potentially. You may have engaged with the Dispute Settlement Centre of Victoria. There may have been a letter of demand sent. There can be lots of things you do before you actually decide I'm going to file a writ. So what we are talking about is this period of time in here, which is pre-trial. Okay? And if we move this down and create a nice pre-trial timeline down the bottom, pre-trial will begin with pleadings, and namely the writ. Okay? And we know that there's quite time frames on the return of documents. Okay? So pleadings might run from here to here. Okay? But then what we need to be aware of is discovery isn't something that just happens for a short period of time. Discovery will run right up until the trial starts. So any evidence you find during that time you need to file on your affidavit of documents, etc. But also directions hearings might occur here and here and here. And maybe at this directions hearing, the judge sends you off to mediation and you leave the pretrial process for a while to go and try mediation. Maybe at this directions hearing here, the judge convinces you to agree on some claims. And then maybe at this third directions hearing, you finally timetable witnesses and prepare for trial. So the judge has actually ordered you off into other things like mediation or got you to agree on some claims so that the trial is shorter. So what we need to be aware of is we are focused on this section at the moment, but lots of things happen before you go to trial. And then obviously there's the trial itself, which will look at key roles people play. Explain the purposes of pretrial procedures using examples. I have a prepared answer for this, so we'll fly through it because we are at nearly 25 minutes. This is the sort of question you might get. Explain the purposes of civil pretrial procedures with reference to one specific pretrial procedure or with reference to one example. And an answer might look like this. It's quite detailed. You'll see here, I identify the purposes. The purposes of civil pretrial procedures are to inform the parties of the details of the dispute and also promote negotiation and potential settlement. And then I use my example. For example, discovery. Parties will engage in full and honest disclosure of all the evidence. This informs both parties as they are able to see the evidence that will be used to support the claims. so responding to that one. And it promotes negotiation and settlement, as one party may see the strength of the other party's evidence and decide that an out-of-court settlement is more desirable, as they will inevitably lose in court and have no control over the remedy. So number 2 there, promotes negotiation and potential settlement. So there I've identified some purposes, and then I've used an example to illustrate 2 of them, 3 marks. Let's look at the principles of justice. You want to pause here and have a go yourself, or we will flick through and I'll show you in 3, 2, 1. It's all about fairness. Generally, pretrial procedures don't actually inhibit fairness in any way. It ensures that all the evidence comes to light, meaning the verdict will be based on the truth. You are legally required to prepare or present any evidence that could help resolve the dispute. Directions hearings allow the impartial third party to help resolve the dispute as well through those conciliation methods. It's equal because both parties receive copies of all documents. However, the filing of these documents and requesting documents, etc., is all needs legal representation. This is expensive, as we know, so it inhibits access, but it also means that if you have weak or lesser representation, you're not on equal footing with the opposing party. The other thing with access is that it's such a long process through discovery that one party can actually use this to their advantage, perhaps if they have more funds, and they can do what's called bleeding the other party. And this is where they increase the costs the other party has to pay by constantly requesting documents, sending interrogatories, that sort of thing, to keep delaying and pushing things back, so they have to spend more money. The aim being that they'll realise that they need to settle, perhaps for less than they deserve, in order to not run out of cash and in order to actually be able to finish the dispute. However, by making both parties outline their claims, it ensures both parties understand exactly what's going on. It ensures trials are run quicker so you can hear more disputes, and therefore all of these pretrial procedures promote access. So synthesizing, I'm just going to provide you a couple of links here in the comments below. Supreme Court forms. So this is a link on the Supreme Court website that literally has blank copies of writs, subpoenas, so requesting documents, statement of claims, that sort of thing, notice of appearance, etc. So you can have a look there and just see what the forms look like. And then I'll link you to the Supreme Court's class action section. This has a list of all current class actions, which is great for helping you further understand representative proceedings. But also you can click into each class action and you can see filled out copies of the writ and statement of claim and all the documents involved, so you can actually get an understanding of what's happening in those disputes. So I'd recommend you check that one out, definitely. Absolutely, utterly failing with my 20-minute time frame, but this was quite a dense point looking at 3 specific pretrial procedures. Let's hope that you understand the purposes of different civil pretrial procedures and you can explain them with reference to pleadings, discovery, and directions hearings. It's been another video for the Legal Studies Guy. Please leave feedback either on YouTube below or through direct emails. And I hope to see you shortly for video 3.2.6.